Bryan Kohberger wants to delay his case following a massive leak of evidence detailing the state's case, as Judge Hippler holds a sealed hearing to meet with the attorneys and the attorney for Kaylee Gonsalves' family about the role of victims. I look at what all of it means for the case. Welcome to Crime Fix. I'm Angenette Levy. Bryan Kohberger says his trial should not begin in August. He says it's too soon for many, many reasons. The big leak of evidence to Dateline is just one of those reasons why Kohberger wants his trial delayed. And we're finally hearing from his lawyer, Ann Taylor, about the leak, what she thinks about it and the Dateline episode. And let me tell you, she's not happy. She's not happy at all. And like Judge Hippler, she thinks it came from somebody on the prosecution or law enforcement side. I'll detail everything she says about the Dateline episode. Plus, there are other reasons why she says the trial should not start in August. She says she just needs more time to prepare. We've heard that from her before. Kohberger maintains his innocence in the murders of Maddie Mogen, Kaylee Gonsalves, Ethan Chacon, and Xana Kernodle. The four friends were stabbed to death in the home on King Road on November 13th, 2022. Kohberger was arrested at his parents' home in Pennsylvania more than 6 weeks later. The FBI, you'll recall, used genetic genealogy to identify Kohberger as the source of male DNA found on this part of a K-bar knife sheath. It was found at the crime scene next to Maddie Mogen's body. Jury selection is scheduled to begin on July 30th, and opening statements are scheduled for August 11th. But Kohberger's lawyers say they simply need more time. They haven't had enough time, they say, to go through all of the evidence to prepare a proper defense, especially since Kohberger's life is on the line. Taylor wrote, "Cutting off this review before counsel can complete it would significantly prejudice Mr. Kohberger. The state's case is circumstantial. Mr. Kohberger was not identified as a person of interest until weeks after the crime, and after he was identified, law enforcement ceased investigating all other possibilities. While counsel can explain this in trial, every experienced trial lawyer knows that trials are essentially story battles, high-stakes duels where the prosecution and defense each tell competing narratives about the same set of events. Ultimately, the jury decides which story feels more true and more coherent, even though the burden of proof rests with the prosecution and the defense bears no burden at all. Humans are driven by narratives. That reality forces the defense to counteract the state's narrative with another compelling story. Now, as it stands right now, the story Ann Taylor plans to tell the jury is that Bryan Kohberger is innocent and that somehow the sheath got to the house on King Road, but it wasn't Kohberger's doing. She also plans to tell the jury there were two killers, and neither was Bryan Kohberger. She alluded to this at a hearing back in April.
Your Honor, we have produced an expert that believes that it's likely that there were two people, two weapons. That
Dobson testimony about the degree of intoxication goes to the what I'm assuming was, given that degree of intoxication, the ability to fight back. In rebuttal to your experts, as I understand it.
I think that's what the state says. I don't think that's proper rebuttal. Well, because we didn't talk about intoxication, because the state's medical examiner talks about defensive wounds anyway, so this would seem to be contradictory with other testimony that they intend to put on. We are not contesting the intoxication level of any of the deceased.
So right there, we found out that Maddie Mogen had no defensive wounds and could not fight back, even if she wanted to. The defense also argues they need more time to work on their alternate perpetrator theory. Ann Taylor writes, "As scholars explain, here the central issue is the identity of the perpetrator. Even a reasonable doubt case implies a story that someone else did it, but it is a story with a huge hole, and one likely to be ineffective. The jury might speculate that if this defendant did not do it, there should be at least some evidence suggesting that someone else did. And it is especially incumbent on counsel to become aware of all existing evidence, because alternate perpetrator evidence may be deemed inadmissible under Idaho law if it merely tends to mislead the jury that another person committed the crime. Last week, the defense submitted information to Judge Hippler about alternate suspects that they'd like to present to the jury at trial. But Judge Hippler told Ann Taylor she needs to have evidence to back it up. She talked about reviewing the tens of thousands of tips and stumbling upon just one at a hearing in April.
We're not completed with that. I think I've read most of the police reports in this case, but I haven't read the thousands and thousands and thousands of tips that came in on this case. Don't think they're all not relevant, though. Recently, we came across a tip just in trying to work through some of these issues. We came across a tip that would appear to be an alternate suspect, and we're trying to work through that as rapidly as we can. It was quite a surprise to come up with that. There's got to be more in there that I need to know.
I want to tell you about OneSkin. They are sponsoring today's episode of Crime Fix. Let's be honest, being on camera as much as I am, having the right skincare products matters a lot. Our skin changes as we get older. Dryness, deeper wrinkles, even crepiness can be frustrating, but there's a game changer out there, and it's called OneSkin. OneSkin was founded by an all-woman team of scientists who developed the proprietary OS-01 peptide. This peptide targets cellular senescence, a key hallmark of aging. It's scientifically proven to decrease lines and wrinkles, boost hydration, and help with thinning skin. They have over 4,000 five-star reviews for their full line of face, body, sun, and travel-size products. One of the things I like most about OneSkin is how easy it is to integrate it into my daily routine. Just a few simple steps and I'm good to go. For a limited time, you can try OneSkin and get 15% off using the code CRIMEFIX when you check out at oneskin.co. That's 15% off at oneskin.co with the code CRIMEFIX. And remember to tell them we sent you when they ask you where you heard about them. Invest in the health and longevity of your skin with OneSkin. Your future self will thank you. Trust me. So Ann Taylor's conceding the defense doesn't have all of its ducks in a row when it comes to the alternate perpetrator theory and evidence, and prosecutors have already indicated they would object, saying there's only one perpetrator, and that's Bryan Kohberger. Kohberger's defense team also reminds Judge Hippler of Kohberger's additional rights, since this is a capital case, and the issues that could arise if a jury isn't presented with all of the mitigating evidence in the penalty phase if the case reaches that point. The defense references the life history investigation. Taylor writes the defense must conduct an ongoing, exhaustive, and independent investigation of every aspect of the client's character, history, record, and any circumstances of the offense or other factors which may provide a basis for a sentence less than death in order to meet their constitutional obligations. This investigation would reveal any red flags that could be looked into, which would take time. Taylor says she's obligated to investigate beyond the mere surface level for mitigating factors, to add context to Kohberger's life so the jurors could understand his choices, his behavior, and lifestyle in which he engaged. Taylor essentially says she has to be able to present a full picture of who Bryan Kohberger is to the jury by getting to the heart of who he is, and that requires her to gather observations, records, and interviews to show, quote, how others perceive an individual, and his place in the world adds an additional layer of complexity to understanding the nature and magnitude of psychosocial stressors he encounters. Another reason this life history investigation is required is so counsel can identify all of the experts they need. Taylor says experts are essential in telling a client's story in a way that will answer all of the important why questions for the jury. Taylor also raises a point that going through discovery is much quicker for the state because of all of the resources prosecutors and police have. Taylor writes, thus, defense counsel's review of the discovery is not merely checking a box. It goes to the very heart of the ability to prepare and present a defense, reviewing and integrating all of the evidence in order to tell the jury a coherent counter-narrative is essential to defending Mr. Kohberger's life. The state and its superior investigatory apparatus has spent years honing in on one specific story, that of Mr. Kohberger's guilt, and ignoring all other possibilities. Now let's get into the latest development, the evidence leaked to Dateline. Taylor says that Dateline aired information in its 2-hour special that was prejudicial and unreliable, and therefore likely inadmissible, meaning the jury would never see it. But viewers saw it if they watched. It included information about Kohberger's Google searches for pornography, about women being asleep or passed out, and Google searches about serial killer Ted Bundy, selfies from Kohberger's phone showing him wearing all black and a hood, and his viewing of stories about the Idaho murders and searches for his own name. This information had not been made public before. It wasn't in court documents, and Dateline reported it obtained the information exclusively. Ann Taylor says a continuance is necessary because these leaked materials to Dateline were carefully curated to construct a narrative of guilt. And there's another reason she wants a continuance. Another book is coming out right before jury selection begins. Best-selling author James Patterson and journalist Vicky Ward are releasing a book entitled The Idaho Four, An American Tragedy, in July, 16 days before jury selection begins. The book's cover boasts unmatched access, with months of local reporting with more than 300 interviews with victims' families and local law enforcement. Local law enforcement is, of course, covered by the non-dissemination order. Judge Hippler has already said he suspects that order was likely violated by current or former members of the prosecution team and law enforcement. Yikes. Taylor went on to criticize the Dateline episode, saying it had a lot of dramatic effects, like reenactments and music, coupled with emotional interviews with people connected to the victims. The show is another reason she wants the trial delayed. Taylor writes, in sum, the 2-hour Dateline episode is uniquely prejudicial in both tone and content. It constructs a speculative narrative around motive and guilt, features emotionally manipulative production elements, and amplifies unsupported theories through self-styled expert commentary, all timed to air just weeks before trial, when juror impressions are most vulnerable and voir dire least equipped to neutralize such deep-seated bias. And remember, Judge Hippler wants an investigation into the leaks, and so does Ann Taylor. She writes, depending on the results of the investigation into the leaks, a continuance may be inadequate. Once the sources of the leaks are identified and the full extent of misconduct revealed, the violations could warrant remedies more serious than delay. At the very least, however, a continuance is essential to allow the extremely prejudicial impact to partially subside and to give the court and the defense time to fully investigate and address the scope of the violations.
All right. So to talk about the defense's request for a continuance, I want to bring in Philip Dubé. He is court-appointed counsel out in Los Angeles, has done that type of work for many, many years. Philip, I'm not shocked by this request at all, especially given the Dateline special, but it seems to me that Ann Taylor had been working on this motion for a while. She'd been cooking this thing up, this 40-page motion for a while, and then the Dateline bomb lands in their lap. And they kind of slide that in at the very end. What are your thoughts?
I got to tell you, I actually sympathize with Miss Taylor, and I've been there. I really have. Here you have a guy whose life is on the line, and she's basically telling the court, I'm not ready. And in all fairness to Mr. Kohberger, he has a right under the Sixth Amendment to effective assistance of counsel. And the case law has interpreted that right to include the right of counsel to be prepared. If counsel is not prepared, then it would be unfair for the state to proceed, because really then it's almost like a trial by ambush. And it's not Mr. Kohberger's fault that his counsel is not ready. But she is, under Idaho law, setting forth the requirement of good cause. Good cause to delay the trial means that she needs more time to prepare, to investigate, and certainly to look into that Dateline leak. That Dateline leak is significant constitutionally and statutorily for Bryan Kohberger, because under Idaho law, if that leak is in any way, shape, or form ascribable to the prosecution or law enforcement, she might be able to get counts dismissed or the case dismissed based on outrageous government conduct. And she owes it to her client to look into it, to see if the state or law enforcement had a hand in that leak. And if they did, I'm telling you now, I could see a judge maybe kicking a count. Now, the practical reality of it is it's going to be a very unpopular ruling, and she would have to show outrageous government conduct. And on these facts, I'm not so sure that law enforcement or the DA's office had a hand in that leak. We saw something similar with the Richard Allen prosecution, the Delphi murders, where defense counsel had all the discovery, crime scene photos, autopsy photos in their conference room.
Sure.
And somebody misappropriated them and then leaked them. Well, it's not so outrageous or ascribable to the attorneys that happened, but instead you ascribe it to the person who actually did it. And a dismissal would be unfair under those circumstances.
Sure, of course. And obviously that leak in that Richard Allen case was, completely inappropriate and horrible. It showed crime scene photos of Abby and Libby. It was awful. But this is on a much larger scale. And, Philip, this was discovery material. Judge Hippler made it clear in his orders, ordering both sides to preserve all communications with people about this stuff. He made it clear he thinks it did come from the state side, whether it was a current or former prosecutor or a current or retired member of law enforcement. He's made it clear. He thinks it came from the state side. So the law enforcement side of things, and he's made it clear too, he wants an investigation. So if it did come from law enforcement, and there is a clip out there floating around of Keith Morrison saying they've developed a long list of people on the inside who are good sources. I mean, who would have access to that? This is discovery material. This is stuff off of Bryan Kohberger's phone, that Google searches, his photos, all this stuff that your average Joe wouldn't have access to.
All the intermediaries of the attorney-client relationship would have most of the discovery. So that means, first of all, Ms. Taylor and her team, meaning her paralegals, her associates, her second chair, and whoever else she has. Additionally, anytime she appoints an expert, they get the file as well. Now, does that mean the expert leaked something? Who knows, but I sincerely doubt it, okay? But moreover, the prosecution has it. And they have a huge office of people. They have secretaries, they have paralegals, they have social workers, they have their own investigators. And then you have the outside agencies, namely the law enforcement agencies that are working with the prosecution. So there's no way to know unless you open up an investigation. But let's assume the judge appoints a special prosecutor. Based on my research, it's only a misdemeanor if somebody did that, or a contempt of court. A contempt of court under Idaho law carries 5 days max in the county jail and a fine. If you find that it was a form of obstruction of justice, and in other words, obstructing a public officer in the performance of duties, and in this case, it would be the judge. The judge is the public officer. It's a misdemeanor. So you really want to open up a huge investigation, appoint a public prosecutor, a special prosecutor, so you can get somebody on a misdemeanor. At some point, you have to cut your losses and use the voir dire process to find out what, if any, effect this has on a jury pool out there at large. Because I think that this can be cured during the voir dire process. You merely find out from all the prospective jurors what, if anything, they've heard, what, if anything, they may have seen on television. Did they even see the Dateline episode? If not, then in the end, it really could be much ado about nothing.
The Dateline part of this is just one piece of this puzzle. And, we'll move on to the other pieces of the puzzle here in a moment. But, it appears there is probably more than one potential leak. And so let's say somebody that wasn't a law enforcement officer handed this material that is discovery material to Dateline. What if it was a law enforcement officer who handed it over to a third party to work as an intermediary or a proxy, whatever? That's still a violation of the non-dissemination order, and it's still potentially a violation of Bryan Kohberger's rights.
Of course. Remember, all of these materials are under, euphemistically, we call it a gag order, but really it's a protective order. And it's designed to prevent him from being prejudiced pre-trial. The goal is to make sure he gets a fair trial where he gets an untainted, impartial jury. And if everybody got a taste or a whiff of the evidence and maybe formed final opinions about him, he's not going to get a fair trial. But it goes back to what I said earlier, why Ann Taylor wants more time to look into this is because if she can show that this was in fact an intentional leak on the part of law enforcement, her remedy is to bring a motion for a dismissal based on outrageous government conduct. And the court can suppress evidence, the court can kick counts, the court can dismiss the entire prosecution outright. So there's a lot at stake for her client. And truthfully, I think it would be legal malpractice for her not to look into it. She now has something to hang her hat on. And that would be fascinating to see how courageous Judge Hippler would be on these facts. Seriously doubt it. There's a body of case law already developed on this issue, not just in Idaho, but federally, where prosecutors and law enforcement have eavesdropped on attorney-client privileged communications and seized on their theory of the case, their defenses, their strategies, their tactics, and even under that set of facts, the courts haven't found that it rose to that level of outrageous conduct, and they denied the motion to dismiss. So even assuming that she brings her motion, it doesn't mean it will get granted, but I still think she's duty-bound to investigate it and to bring it.
Well, and then if the case still proceeds to trial and say they do identify the leak and it is law enforcement and that person's on the stand, she can then grill that person about that as well.
It's fair game. Absolutely. And again, I think criminally, the only thing that could happen is a 5-day contempt in jail. Yeah. Or they could file that misdemeanor, which I doubt they would do. You cannot compel a prosecutor to file criminal charges against their own, especially if it's just a measly misdemeanor. There's not enough meat in it to even pursue it. But I can tell you, whoever did this, their career is over.
Right. Let's go now to the other issues. She says, I haven't had enough time. I'm not ready, like you mentioned earlier. I haven't had enough time to investigate all the theories of the case, alternate suspects, all that stuff. I need more time. Simply, I just need more time. And, I need more time to look into mitigation stuff, family history, all this stuff. And this is a capital case. And she's basically saying to the judge, you might be causing, by not giving me more time, reversible error.
And she's absolutely correct. It is not uncommon in the criminal defense world where counsel has a capital case that has been pending for 4 or 5 years. It can take a long time to work up that mitigation. I cannot tell you, Angenette, often we have to send investigators or we ourselves have to travel abroad to meet with ancestors, to meet with relatives of our client. They live in Europe, they live in Africa, they live in Central America. We have to bring interpreters with us to interview people, get statements, to find out what, if anything, went on during that client's life. What went on in their childhood? What went on in school? What went on in utero, for all we know? What was the client exposed to during gestation? All of that has to be vetted because a jury could hang their hat on for purposes of a mercy verdict. And if you don't look into it, it could be a form of ineffective assistance of counsel because the client has that right, not just in the guilt phase, but also in the penalty phase to have the effective assistance of his counsel. And to let it go and to not even try to get more time, I think it could win a reversal, maybe on the penalty phase, but not on the guilt phase.
So, Philip, if you're a betting man, does Judge Hippler grant this continuance?
I'm optimistic. She's going into court with really valid grounds. She's not saying, look, I have a prepaid planned vacation. I'm going to a destination wedding, in Cabo San Lucas, anything like that. She needs the time to work up her client's case. And to turn her down when she has so feverishly asked for it and shown the good cause, I think his hands will be tied to turn her down. Now, what he might do is give her a short continuance and keep her on let's take a look at your progress maybe in a month or two and then revisit the issue, but maybe not give her as much time as she wants for now. But I think for now, he should give her at a minimum a brief continuance so she can show good faith efforts and in earnest that she needed that time.
What's brief? Like in court time, that could be, what is that, 60 days, 30 days? What's brief?
I think 90 days would be fair to keep her on a short leash. I mean, the practical reality of it is 90 days is not a long time. And when you need to do investigations, interview people, get people out in the field to canvass, talk to people, get statements, turn it over to the prosecution, they are likewise going to need time to look at it so they can rebut it. Last thing you want to do is ambush the prosecution with all your investigation and leave them hamstrung during the mitigation phase of a trial. So it kind of works both ways, and it could be that the prosecution might need time. Now, oftentimes what we do too as defense lawyers, we stipulate to a reasonable continuance for the prosecution. So even though we need the time, we will not object if the prosecution needs more time. So it's sort of a give and take. And if you agree to that, the prosecution won't balk.
Philip Dubé, thanks so much for your time, as always.
Take care out there.
Now, back to that hearing that I referenced earlier about the role of victims. It was sealed, so we don't know what was discussed, but we know that Gonsalves's attorney was invited. Crime victims have rights in Idaho, including the right to be heard by the judge presiding over the case, so it could have had something to do with that. Stay tuned for more information on that. We could learn more if Judge Hippler posts a summary of what the hearing entailed. And that's it for this episode of Crime Fix. I'm Angenette Levy. Thanks so much for being with me. I'll see you back here next time.